Howdy, everybody. This is Brian Foley. We're going to be going over Texas Rule of Evidence 505, and this one is called Privilege for Communications to a Clergy Member, and that means like somebody with a church, something like this. And there is a definition. Let's read the definition. A clergy member is a minister, priest, rabbi, accredited Christian Science practitioner, or other similar functionary of a religious organization, or someone whom a communicant reasonably believes is a clergy member. So if you have a friend who's dressed up as a priest for Halloween, but you don't recognize them, you really think they're a priest, you confess something, if you reasonably believe that they were a clergy member, then even that would count. A communicant in this statute is a person who consults a clergy member in the clergy member's professional capacity as a spiritual advisor. And then a communication is confidential if it is made privately and not intended for further disclosure except to other persons present to further the purpose of the communication. Meaning, you can go to your priest, tell them you murdered somebody, and they're not supposed to tell. You can go to confession, and they are not supposed to tell. A communicant has a privilege to refuse to disclose and to prevent any other person from disclosing a confidential communication by the communicant to a clergy member in the clergy member's professional capacity as a spiritual advisor. And this can be claimed not just by the communicant, meaning the person who gave the confession, but their guardian, a conservator, a deceased communicant's personal representative. So if you said, I didn't really own in lawyers, we always say Blackacre, which is the name of property for real estate. But I didn't really own that house, I was just squatting there. If you said that to a priest because you were feeling bad about that, and then there was a lawsuit and they wanted to bring in that priest to testify to that, your descendants who inherited that land can prevent the preacher from coming to testify. So the clergy member also to whom the communication was made may claim this privilege on the communicant's behalf and is presumed to have authority to do so. So there are some cases on the line here. Simpson versus Tennant from 1994. The Simpson Court of Appeals in Houston held that the identity of the person seeking religious counsel was also protected. So you can't even say, oh, well, there was this murder, and then this person ran from the murder scene straight to the church and then into the confessional. Who was that person? Nope, can't tell you. That's what that case says. The privilege even covers group counseling and marriage counseling if done with the expectation of confidentiality through a clergy member. And that is from In Re Grand Jury Investigations 918 F. 2nd 374 from the Third Circuit 1990. This is, let's see. I have a note here. Always take notes. If you think I'm coming up with all this stuff right off the top of my head, we do it. So a clergy member is the language here. When I started practicing back at the beginning of my career, it used to be called a clergyman, but they've changed that to clergy member since then. I thought that was neat that you might be interested in knowing that changes and evolves the way we handle these things and the way the wording of these statutes. It gets updated every so often, and that's one of them. So thanks for listening in. As always, this is for educational purposes only. Hope you've enjoyed discussing Rule of Evidence 505.